appeared worthy of belief, the accuracy of the witness's memory, the appearance and demeanor of the witness while testifying, whether the witness has an interest in the outcome of the case, whether the witness has any reason for not telling the truth, whether what the witness said seemed reasonable or probable, whether what the witness said seemed unreasonable or inconsistent with the other evidence in the case, and whether the witness had any friendship or animosity towards other people in the case. You should consider these factors in deciding the credibility of all witnesses, whether they happen to be ordinary citizens or police officers. In short, you should consider the testimony of each witness and give it the weight that you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It's up to you. In deciding whether to believe a witness and how much of his or her testimony to believe, you should consider both the direct and cross-examination of the witness. You need not believe a witness's testimony simply because it is uncontradicted. As I said, the determination of witness credibility is up to you. In deciding whether you believe a witness, you may consider whether the witness made statements before trial which were not consistent with what the witness said at trial. If the witness made an inconsistent statement before trial, you may use that statement in deciding whether to believe the witness. You may not use the statement made before trial as proof that the facts in the statement are true. The statement made before trial is only to be used by you in deciding whether to believe a witness. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss how convinced one way or the other you must be, and this is referred to as the burden of proof. Under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove her innocence. As I told you earlier, she enters this courtroom an innocent person, and you must consider her to be an innocent person until the state convinces you, beyond a reasonable doubt, that she is guilty of every element of the alleged offense. If, after all the evidence and arguments, you have a reasonable doubt as to the defendant having committed one or more elements of the offense, then you must find her not guilty. Members of the jury, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a fanciful or frivolous doubt, nor is it one that can be easily explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proved all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. Please remember that in order to reach a verdict in this case, whether it is guilty or not guilty, your verdict must be unanimous. I'm now going to discuss the definition of the crime with which the defendant is charged. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts, an intent and an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what her intentions were. The word intent refers to what a person mentally believed her physical acts will accomplish, and the word act refers to a physical deed. The state has the burden of proving beyond a reasonable doubt a separate intent and a separate act for each crime charged. Thus, for a person to be guilty of a crime, she must have done the following two things. She must have mentally intended to do something that is criminal, and she must have physically acted to do something that is criminal. Unless a person both intended and acted to do something criminal, that person has not committed a crime. Many people do not realize that sometimes the only reason two identical acts are given different names is that they refer to different intentions. For example, assume that two drivers of automobiles hit a person crossing the street. If one of the drivers intended to hit the pedestrian and the other one did so recklessly, they would not be charged with the same crime, because while they both committed the same act, they had different mental states. Now, whether the defendant acted with the required intent is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances and evidence. In deciding whether or not the state has proved that the defendant acted with the required intent. Charge number 571918C alleges that the defendant committed the crime of resisting arrest or detention in that she knowingly interfered with a person she recognized to be a law enforcement official seeking to effect her arrest when she struggled with Officer Elston, Sergeant Mucci, and Sergeant Patty as they attempted to handcuff her. The definition of this crime has 4 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant physically interfered with another person, and 2, the defendant knew the other person was a law enforcement official, and 3, the official was trying to arrest or detain the defendant, and 4, the defendant acted knowingly. These are the elements of the crime of resisting arrest or detention. Certain terms in the definition need to be further defined. With respect to the first part or element, as indicated, the interference must be physical. Verbal protests alone do not constitute resisting arrest or detention. With respect to the third part or element, it does not matter whether the arrest or detention was illegal. The state does not have to prove that there was a valid legal basis for the arrest or detention. Law enforcement officials are justified in using non-deadly force upon another person when, and to the extent they reasonably believed it necessary to effect an arrest or detention, unless the officers know that the arrest or detention is illegal. The fourth part or element refers to the defendant's mental state. A person acts knowingly when she is aware of the nature of her conduct. The state does not have to prove that the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware that her conduct would cause the prohibited result. Whether the defendant acted knowingly is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances and evidence in deciding whether the state has proved beyond a reasonable doubt that the defendant acted knowingly. Members of the jury, the principles of law that I have given to you are intended to guide you in reaching a fair result in this case, which is important to both the parties in the courtroom and the court. You are to exercise your judgment and common sense, as I said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. When you have considered and weighed all the evidence, you must make one of the following findings with respect to each charge, with respect to the charge that is before you. If you have a reasonable doubt as to whether the state has proven any one or more elements of the offense charged, you must find the defendant not guilty. However, if you find that the state has proven all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. As I've said before, your verdict must be unanimous. All 12 jurors must agree on your verdict. When you have arrived at your verdict, let the bailiff know, and you will be returned to the courtroom where the foreperson will render that verdict orally in response to questions from that the clerk of court will ask you. The foreperson should see to it that the jury takes up the issues that are before you. He or she should see to it that each juror has a full, fair, and adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. You should choose the foreperson as your first order of business. Each juror's verdict must be his or her own, and it should not be made out of a need to agree with everyone else. Yet, in order to bring 12 minds to the same decisions, jurors have to respect and listen to one another's opinions honestly. I suggest that deliberation is a 3-stage process. First, each juror should decide for yourself your opinions and views of the evidence in the law. Second, you should listen to what your fellow jurors have to say about the evidence in the law. Third, you should speak up and let your fellow jurors know what your opinions and views are of the evidence and the law. You should remember these 2 rules when you disagree with other jurors. 1, respect and consider the opinions of other jurors. 2, but in the end, reach your own decision. If during deliberations it becomes necessary to communicate with me, you may do so only in writing, signed by the foreperson or one or more members of the jury. Please give that note to the bailiff and he will bring it to my attention. No member of the jury should ever attempt to communicate with me except by a signed writing, and I will communicate with you on anything concerning the case either in writing or orally in the courtroom. At the risk of being repetitive, let me say again that nothing said in these instructions is intended to suggest or convey in any way what your verdict should be. The verdict is exclusively your duty and your responsibility. Thank you for your attention. In a moment, I will select the alternates first. However, I would like to see the parties at the bench. At this stage, ladies and gentlemen, I have to select two alternates. The alternates must remain in the courthouse. In the unlikely event that we need to substitute an alternate for a juror because of illness or family emergency, that's why we ask the